the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.
Hello, everybody. My name is Juan Carlos Brando. Thank you for joining us today at this noon show on Thursday, like every Thursday that we have the chance to talk to you all and give you some information regarding to the immigration field. Today is a very interesting day in many areas of the United States. Well, here in Atlanta, we are right now in a very low temperature, which is not usual for this time. We're just experiencing around the 40s in this day, and this morning was below 40. So it's very interesting how the weather is changing in this city. But what is not usual is that the weather is changing all the time in the immigration field. As usual, for the last 4 years, we had a lot of changes day after day. Now we're having positive changes in this new government, this new era, with this new government. So let's see what's going to happen in the next few days. Today, we're talking with the attorney Fabiola Cini, which is one of the attorneys in the law firm of Margaret W. Wong and Associates, and she will be talking with us, answering your questions all in English. And she has been working with this law firm for over 15 years, if I'm not wrong. And well, she's one of the best attorneys, I would say, in the East, and I would say in the whole United States. So thank you so much, Fabi, for being with us today and for helping a lot of people answering their questions. How are you doing today?
Good. How about you? Thank you very much for having me.
Thank you so much, Fabi. And yeah, it's exciting because we have a lot of questions from the audience today. And also, we have many changes that are coming day after day, but thankfully they are positive changes, not like in the past that we were having beat after beat. We were really struggling about what was going on in this country. But let's start summarizing a little bit what's going on in the United States in the last 3 months, if we could summarize a little bit of it.
Well, first of all, in the area of enforcement of deportation, there is this new regulation or memo that sets all the priorities for removal and deportation. So while under the prior administration, all aliens who are in deportation proceedings were priority for removal, immigration has set new priorities. So first priority for removal will be people who have criminal records, those who do not have ties to the United States, those who are considered danger to the society, and so forth. So these are the first priorities for removal and deportation. We can make arguments that whoever has been here for many years, who has ties to the United States, who is married to a U.S. citizen, who has children born in the United States, is temporarily not considered a priority for removal or deportation. However, as I said, this is case-by-case basis. The government is still waiting for guidelines from the White House currently, and then we'll see how these priorities will play in the day-to-day cases. So we're still waiting for guidance from the government. As I said, these are new developments. Every day is a new day in the immigration field.
Thank you so much, Attorney Fabiola, for this information. And yeah, it's interesting how even the public charge went out of the field in these last 2 months. We still need to be careful about what all the information is regarding to a filing, but it's interesting that so many changes are coming. So we have the first question this afternoon in this show, and I would like to start by asking this one that is coming from a person who sent it via inbox, and this person is saying the following. Um, when I flew to LA last March 30th, they searched my phone. My visa got revoked due to unauthorized work during my stay while I am on my tourist visa. I didn't overstay. I did it in 2018 and 2019. The officer gave me a choice to voluntarily withdraw my visa when I was at the Los Angeles airport. I am wondering if it's possible for me to apply for K1 or CR1 visa. I hope you can help me. Thank you.
Thank you for the question. Sure, the possibilities are open to apply for the K1 and the R1 visa. However, we have to look into the records at the time he applied for admission to the United States. Because if he came to the United States with a non-immigrant visa, a visitor visa, but his intention was to work, and if the CBP officers found records in his phone showing that his intent was to work in the United States, he is in violation of the non-immigrant visa regulation. However, sometimes they do give the option to withdraw the admission and do not make remarks on the passport. However, it does not mean that they did not make remarks in his file. We have to look into this file. If there is a notation about a misrepresentation, then it may be a problem when he applies for the K1 and R1. He may need a waiver. So as I said, it is absolutely possible and chances are open that he applied for those visas, but we have to look into the records. If there are issues that somehow will make him not eligible, he may need to apply for a waiver or even be denied. These type of visas are always discretional. There is always issues. He has to consult an immigration attorney to look into his file, obtain records from the CBP, and see what is in the records. But yes, he's asking if he can apply. Absolutely,
Okay.
he can apply. But it may be issues when he applies. That's why he has to consult an immigration attorney.
Thank you so much, Attorney
Thank you.
Fabiola. Don't forget that the phone number is 216-279-3984. 216-279-3984. That's the phone number that you can call in any city of the United States, and they will take care of your case. The attorney, Margaret W. Wong, has been working in this field for over 40 years, and she has offices in 9 cities of this country: Atlanta, Cleveland, Columbus, Chicago, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216-279-3984. 216-279-3984. We have the next question. This is very interesting. This person says, I entered on a tourist visa 12 years ago. With this tourist visa, some people told me that I could apply for some kind of work permit. I told them that I wanted to do that. They said that they were going to help me, and I overstayed my visa. Then I got deported, and it has been 9 years ago. All of a sudden, I came back to the United States on my tourist visa, and they didn't stop me in the airport. They apparently didn't notice that I left the United States on a deportation. Now I got married to an U.S. citizen, and she wants to apply for me. What are the chances that they could get the information that I was deported? They took my fingerprints, my biometrics, and I don't know why they let me enter again, but when I tried, they just let me in.
Well, we don't know whether he took voluntary departure at the time or if he was ordered deported. There are certain bars, 5-year bar, 10-year bar, so we don't know what's in his file. However, the question is, does immigration have his records? Absolutely, yes. The records are there. They sometimes do overlook things when someone enters, but I doubt that things are overlooked. So probably he had a 5-year bar. As I said, we don't know without seeing the records. He can file for a green card based on the marriage to U.S. citizen. More details are needed, and he needs to discuss the case with an immigration attorney. This is something that we can discuss online. So apparently our personal information that we have to obtain from him, and then it depends on when he's going to apply. This is important. The time frame. So I don't know when he entered. Did he enter recently? What's his intention? Does he intend to marry her right away or wait? But absolutely, that's an option. He entered as a visitor, and even if he overstays, he can apply for the marriage case, which is the I-130, the 485 applications based on the marriage. He has to obtain his records. A waiver may be needed.
Thank you so much.
So, as I said, absolutely, that's an option, and he can do it, but don't make any decisions until an immigration attorney reviews your full and complete file.
Yeah, that would be the recommendation for this case. This is very important that you can have this information before you try anything.
Absolutely.
Yes. So, Attorney Fabiola, if they find out that he was deported and that he came back, can she still do the I-130 for him?
Yes, he'll need waivers. He was admitted, and the admission is legal. So he was legally admitted into the United States. He can definitely file for the marriage case. As I said, the timeline is very important, so he should consult an immigration attorney, review the file, and then go from there. But yes, he can apply because he was admitted lawfully into the United States.
Thank you very much, Attorney Fabiola. Don't forget that the phone number is just one, 216-279-3984, 216-279-3984. They will help you with your case, with your immigration case, in all the stages of your request. So please don't forget to call this phone number, 216-279-3984, 216-279-3984 is the phone number that you will have to dial, and they will take care of your case. It doesn't matter if you have a good case or if it's a case that you don't really know. After that conversation, they will take care of you. So thank you so much for joining us today. We have another question, which is very, very important. So this is, I am from Mexico. I am gay. I am 41 years old. And my question is, I came 11 years ago because I was abused in my country. I never tried nothing because I didn't have any proof. Can I still apply for asylum with this situation that happened to me?
In this case, I cannot give a blanket answer, yes or no. We have to discuss his case in details. The main issue is why he did not file his asylum within 1 year, because the law says you have to file for asylum within 1 year of your admission into the United States. There are certain exceptions. So if he was a minor, he should have applied by the time that he became an adult. If he had psychological, mental issues, serious medical conditions that prevented him from filing the asylum within 1 year, we can argue for an exception. If he came out as a gay recently, if nobody knew that he had those kind of problems and he just came out, also this may be argued as an exception to the 1 year filing deadline. So, as I said, I cannot tell him he can apply or he cannot. We first have to evaluate his case, talk to him, and see if there is an exception to the 1-year filing deadline, because this will be the key issue. Although he may not qualify for asylum, and if we do not have an argument on the 1-year issue, he can still probably be entitled to withholding of removal. So, as I said, it's absolutely an option that he has to discuss with a competent lawyer.
Much, Attorney Fabiola, for this information. And well, I'm gonna ask you one of the questions that are part of your specialty, which is I've seen you working on 42Bs. So what is the particular aspect that we need to take care of in the 42B? Who could qualify for this kind of immigration request?
ER-42B, or as it's called, cancellation of removal for non-permanent residents, it's a form of relief from deportation or removal. Only those who are currently in removal proceedings can apply for this form of relief. So this is not an affirmative application that you can file with the USCIS or with different government agencies. It can only be filed in front of an immigration judge as a form of relief from removal. Qualifications for the 42B, EOR-42B form: you have to have been here for 10 years or longer by the time the NTA, the Notice to Appear, was issued. You have to be a person of good moral character, meaning no criminal records. There are some exceptions if there are minor criminal records that do not affect your case. So these are, first and the second qualifications, requirements to qualify for 42B. You have to have a qualifying relative. Qualifying relative is a parent who is a U.S. citizen or a legal permanent resident, a spouse who is a citizen or a legal permanent resident, children under the age of 21 who are U.S. citizens or green card holders. So you must have a qualifying relative. And the fourth prong, which is actually one of the most difficult to establish in immigration court, is to show that your qualifying relative will suffer extremely unusual hardship if you are deported or removed from the United States. So these are the four things that you have to establish in front of an immigration judge in order to be granted cancellation of removal. As I said, it's only a relief from removal or deportation, only if you are currently in removal proceedings.
Thank you so much, Fabiola. And don't forget, the phone number is 216-279-3984, 216-279-3984. And there are over 15 attorneys are working right now with the attorney Margaret Wong in a huge law firm that has been working in this field for over 40 years. So thank you so much for your questions. Thank you so much, Attorney Fabiola, for your answers. And we have a few more minutes to answer more questions coming from you, from the audience. And you can ask in English or Spanish. We can translate for you. We also have a lot of people, many countries, even African countries, Asian countries, that have different kind of cases. But let's talk about these cases that are family-based. Can a child apply for mom or dad if they entered illegally?
Well, a child can also always apply by filing an I-130 for mom and dad. However, mom and dad cannot get a green card in the United States if they enter the country illegally, unless they qualify under the provision of 245I of Immigration Nationality Act, And that means that if someone filed a petition for mom and dad prior to April of 2001, and the petition was approvable at the time, mom and dad were here in December of 2000, so mom and dad can get a green card in the United States if they enter the country illegally. So this is one of those exceptions. If mom and dad enter the country illegally, there is an option to apply for a waiver if they do have a qualifying relative, such as a parent who is a U.S. citizen or a green card holder, but they cannot obtain the green card in the United States. They have to pursue consular processing, meaning that once the child's petition is approved, mom and dad, or either one, leave the country, go back to their home country, wait for an interview, and then apply for a waiver. The waiver can also be applied while here in the United States, which will shorten the separation time. But this is only specific cases when mom and dad have qualifying relatives, parents who are U.S. citizens or green card holders. So this is the exception to the rule. If you enter the country illegally, you cannot obtain the green card here. But if you qualify for a waiver, you can file a 601A while here in the United States, then return to your home country to present yourself for an interview for immigrant visa, or if you qualify under 245I.
Thank you so much, Fabiola, Attorney Fabiola, for this information, for this answer. We have another question, very interesting. To file a Form I-130, can you do it if you show proof of expertise in an area of your field? Do you need a labor certification? What if you are now self-employed? I don't understand the question, but maybe you do.
Well, the I-130, it's a petition for alien relative. I'm not sure if the
maybe they mean the I-140?
I-140?
Yeah, probably.
Yes. Okay, so I-140 application for labor certification are two different things. First, you have to apply for a labor certification. Once that's approved, it always is based on the area of expertise. There are different kinds of specialties, employment. You have to have an employment offer. You have to, your employer has to comply with certain requirements. Once the labor certification is approved, you file for I-140, you can file for green card. However, again, the question is he applying here in the United States or is he applying from overseas? If he's here, he has to maintain lawful status until he gets the I-140 approved and until he files for green card. So the correct question, I believe, it should be to file a Form I-140. Before you go to the Form I-140, you have to have a labor certification and you have to maintain lawful status if you are here. You have to have a job offer. And it all depends on your area of expertise, what kind of employment you are seeking, you are offered, if your employer complies with the regulations and so forth. So there is this is a complex case, and it has to be discussed based on that particular case. If there is something specific that he's offered, a job offer, what field, how much money the employer is offering, if the employer can show ability to pay him. So there are many things that we need to know before we can give an answer to the question, because that's just a very general question.
Okay, thank you so much. Yeah, so probably this is about the I-140, and you have to follow the advice that the attorney Fabiola Cini is giving us today. So thank you so much for this interesting question. We have a lot more questions coming in through our inbox. And this next question is, when I am filing a petition, a fiance petition, what do I need to prove? Do I need to prove my income? Thank you.
First of all, you have to prove the relationship. This is very important. So you have to have met your fiance in the last year. you have to show intent to marry within 90 days after your fiance comes to the United States. And of course, you have to show ability to support. But that shouldn't be a problem because you can always get a joint sponsor. So the main thing is to prove the relationship, that you are in a good faith relationship and the intent to marry. Then, of course, ability to support your fiance when he or she comes to the United States. Commitment to marriage is one key issue.
Okay, yeah, it's interesting. It's very, very interesting. Again, next question is, but don't forget the phone number is 216-279-3984. 216-279-3984 is the phone number that you can call to the office of the attorney Margaret W. Wong. The next question is, I have been a citizen for over 30 years. I got my citizenship through, I got my residence through amnesty and then the citizenship. I want to apply for my wife. We have been married for 2 years and she lives in Mexico. She is pregnant at the moment. So how can I do to bring her here now that we are married? We have other 2 kids. One is 3 years old and the other one is 7, but they live in Mexico.
He has to file separate petitions for each of his relatives, his wife and his kids, through filing form I-130, petition for alien relative. So he's a citizen, as if I got the question right, correct? A citizen or a green card holder? Citizen,
He's
right?
a citizen, yes.
Okay, yes, he should file form I-130, petition for alien relative for his wife and his children. Once the case gets approved, which probably is going to take maybe 6 months, 8 months. It depends. Priority time varies. The case will be forwarded to the National Visa Center for the immigrant visa. He'll have to file certain documents with the National Visa Center. And then once the case is referred to the consulate for interview, his relatives will appear there for an immigrant visa interview. There is some forms that he has to fill out, documents he has to provide to show the relationship, to show that his kids are his biological kids, and so forth. Documents to show that he's able to support them financially as a sponsor. Relatives in Mexico have to comply with certain medical examination and fingerprint clearance. So it's a process. But first, he has to start by filing form I-130, petition for alien relative.
Okay, thank you so much, Attorney Fabiola Cini. Our time is up. Time went really, really fast today.
Really.
So thank you so much for your answers. And everybody, thank you for your questions. Don't forget that the attorney Margaret W. Wong has offices in 9 cities of the United States, and she has 15 attorneys working with her. So it's interesting how they take care of your case or of your immigration needs. They go to court with you and for you. They do the motions over the telephone with these COVID issues that we have been dealing with for over 1 year. So please don't forget to call 216-279-3984, 216-279-3984. Thank you so much, Attorney Fabiola, for
Thank you so much for having me. Happy
having
to
us today.
help.
Thank you so much.
Thank you.
Thank you. See you next time. Don't forget to follow our Facebook page in English and Spanish. Is Margaret W. Wong and Associates. Thank you so much and see you next time.
This pandemic has changed the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.